Hello. So today we are going to discuss functions and duties of governor. Functions and duties of governor. Governor is the executive head of a state. Executive head of a state. Within the meaning, Article 153 and 154 of Constitution. 154 vests executive power of the state. Executive powers of the state. Exercise its either directly or through official subordinate to him accordance with the constitution. Under 163, governor as a constitutional head exercise all power concerned aid and advice of CM and council of minister. Okay, so this it includes summon karna, prorogue the session of the state legislature, promulgation of ordinance, giving assent to the bills, and appointments of council of minister. There are certain functions which are possibly exercised by governor in discretion as sending reports to president in 356 and reserving bill for consideration of president in 354 too. So there was like 356, that is the discretionary power of the governor, and 254 reservation of the bill, that is also. So governor appointment किस किस को करता है, the appointing authority, so that's why advocate general, lokayukta, state election commission, chairman member of human right commission, chairman member of public service commission, and state information commission. Now we are going to discuss some articles. First is governor, 153 executive power, 154 appointment, 155 term, 156 qualification, 157 conditions, 158 oath and affirmation, 159 functions, 160 granting pardon, 161 council of ministry, 163 appointment of the CM, 164 executive action, 166 seeking information, 167 nomination to council, 171 summon is 174 message to the house, 175 special address, 176 this is very important, and disqualification of member of legislation, 192 it is also important, assent to the bill, 200 that is also important, and reservation of the bill for consideration of president, 201 financial bill, 202 203 207 till ordinance, 213 this is also important, appointment of judges, 217 also important, oath by judges, 219, and this is also important, oath by judges, 219, and president rule, that was 356, and immunities, 361, and special responsibilities are 239, 243 1, 243 y, 371 d and e, scheduled tribes, that was 244. So governor, article 153, governor of the state, there shall be a governor provided that nothing is this article shall prevent the appointment of the governor two or more state, that was the seventh amendment. Executive power of the governor, article 154 is the state shall vested governor and shall exercise by him either directly through officers subordinate to him accordance with the constitution, and be deemed to be transferred the governor any function conferred by the existing law of authority, prevent parliament or legislature for the state from conferring by the law of authority. So appointment, article 155, appointment of governor, governor of the state shall appointed by president, warrant under his seal, warrant under seal and hand. Term of office, so under article 156, so appointment was in 155, state shall appointed by the president by warrant under, so president इनको appoint करता है 155, but term of office 156, that is hold during the pleasure of president, his post is according to the pleasure of president, and the governor may by writing his hand address to the president, and subject to the foregoing provision of this article, a governor shall hold office for a term of 5 years from date of which enters upon, provided governor shall notwithstanding the expiration of the term continue to hold the office until successor enter upon. Qualification 157, नो पर्सन शैल बी एलिजिबल सिटीजन ऑफ इंडिया होना चाहिए, एज 35 प्लस citizen of India, 2 is only. Next is condition of the office. So article 158 of the constitution, the governor shall not be a member of either house of parliament, and if member of either house of parliament, then any such as appointed governor, he shall be deemed to have vacated his office on the date on which enter upon his office a new governor. Okay, so this is the conditions which is provided 158. So he should not be this is in first schedule, he should not be in the office of profit. That's important. The governor shall not hold any office of profit. The governor shall be entitled without payment of rent of use of official residence, shall be also entitled to emoluments determined by the parliament. So his emoluments will be determined by parliament until provision of emoluments are specified in the second schedule. This is in the second schedule, where the same person appointed governor two or more state. Governor shall allocated among the state in such proportion of president may by order determine. So if he is a governor of two or more state, then president will give his salary and all that as per the proportion. The emoluments of governor shall not be diminished during his term. Oath of the governor. Under article 159 of the constitution, governor, every person discharging the function governor before entering upon the office make the subscribe in the presence of chief justice of India or high court exercising so this judge of the court available oath and affirmation. So क्या oath होती है? I do swear in the name of the God solemnly that I will faithfully execute the office and ability preserve, protect, defend the constitution. I will devote myself to the service well-being of the people. Functions 160. Functions of the governor and the certain contingency. The president may make such provisions discharge the functions of the governor contingency not provided for his chapter. So 160 is what? That is the discharging the functions certain contingency. The president may make the provisions for discharge of functions state in any contingency. Okay, now granting the pardon 161. He can grant pardon, suspend, remit, commute in certain cases. Governor of the state shall have the power to grant pardon, reprieve, respite, remission of punishment, suspend, remit, commute of offence against any law relating to the matter with the executive power of the state. Council of Ministry 163 of the Constitution. There shall be a council of ministry. Chief minister add an advice to the governor. Add an advice to the governor exercise his function, except so far he is by under the constitution required functions. Now, if any question arises whether any matter is or not a matter or the respect which governor is by or under this constitution required to act discretion, the decision of governor is discretion shall be final, and validity of anything done by the governor shall not be called question on ground that ought not to have a discretion. The question whether any and if so what advice was tendered by minister to the governor shall not be inquired in any court. So it will never be inquired. It will not be inquired in any court. Appointments of the CM. Article 164. The CM shall be appointed by the governor and that minister is appointed by the governor on the advice of CM. Minister shall hold office during the pleasure of the governor. Provided that in a state Bihar, Madhya Pradesh, minister in charge of tribal welfare who may additional charge of the welfare of scheduled caste and backward class also. Council of Ministers shall collectively responsible to the Legislative Assembly. Before a minister enter upon office, the governor shall administer to him oath of the office of secrecy according to the third schedule. And a minister who for a period of 6 consecutive months is not member of legislative of the state shall be expiration cease to be a minister. The salary allowances of minister shall be such as the legislature of the state may from time to time by the determine and until the legislature of the state determine shall be specified second schedule. Executive action under article 160 conduct of the business of the states all an order and the other instrument made and executed in the name of governor authenticated as per the governor. Validity order instrument which is authenticated shall not be called in any question. The governor shall make rules for the more convenient transaction of the business and allocations among the ministries and with respect which governor is by under constitutional required. Seeking information, Article 167, duty of CM, respect the furnishing of the information to the governor, and it shall be the duty of the CM to communicate the governor the state all decisions of the council of ministers relating to the administration, to furnish information relating to the affairs of the state, proposals of the calls for, if the governor required to submit for the consideration of the council of ministers any matter taken by the minister but which has not been considered by the council. Nomination to the legislative council. Under Article 175 1, composition of the legislative council, the total number of member legislative council state council shall not exceed one third of the total number of the legislative assembly, provided total number of the members of council state shall is not cease to be any like 40, मतलब one third and 40 से ज़्यादा नहीं. Until Parliament by law otherwise provided, composition of the council state shall be as a provided, as nearly like member of legislative council is total as nearly the one third of the elected electorate consisting of the municipalities या district board local authority से होंगे, and 1/12 जो होंगे elected by the electoral consisting residing in the state and at least 3 years graduates of university. So 1/12 जो होंगे वो graduate of universities से होंगे, at least 3 year तक work किए हुए. Nearly of the 1/12 shall be elected electoral consisting of the person of the 3 year engaged in the like school secondary school से related. Nearly one third will be the shall be elected member of the legislative assembly amongst persons जो भी होंगे legislative assembly से, and remainder shall be nominated by the governor accordance with the provision of clause, like 1/6 will be the nomination by the governor. So the member of the elected under the subclause this chosen in such territorial council may be prescribed under the law of parliament and accordance with the system of proportional representation single transferable vote. The member to be nominated by governor under this clause consists of the person having a special knowledge respect to the namely literature, science, cooperative movement and social science. So it is literature, science, cooperative movement and social science. Summon of the House. Article 174. Session of the state legislation, prorogation and dissolution. The governor shall from time to time summon the House of the state, meets time and place the thing fit, but 6 months shall not be intervened between the last sitting of the one session. So prorogue करता है हाउस को, अदर हाउस ऑफ पार्लियामेंट डिसॉल्व कर सकता है असेंबली को. And message to the house. Under Article 175, right of the governor address send message to the house. The governor may address the legislative assembly and having a legislative council. So either house of legislative state or both house of the assembled together, and may for the purpose of require attendance of the member. The governor may send the message to the house and whether a respect to the bill pending. So send shall be with all convenient dispatch, consider any matter required. Special address 176. So commencement of the first session of the each general election, and the governor shall address the legislative assembly, state legislative assembly and both house assembled together. Provision shall be made by the rules regulating procedure of the house. The disqualification of the member that is given under Article 192. If any question arises whether member of the House of Legislature become subject to any disqualification, 191 question shall be referred to the decision to the governor is final. Before giving any decisions, the governor shall obtain the opinion of Election Commission of India. Assent to the bill. Under Article 200, when bill has been passed by the Legislative Assembly to the state, in case of the state having a Legislative Council has been passed by both the House of Legislature, it shall be presented to the governor, and the governor shall declare either that the assent to the bill or that of withhold assent, that resolve the bill for the consideration of the president. So he will what he do. So in case of the state having a Legislative Council has been passed by both the House of Parliament, it shall be presented to the governor, and the governor shall declare either that the assent to the bill or withhold the assent. Provided governor as soon as possible after the presentation of the bill return the bill for the money bill. It is not money bill. Money bill can't be returned. together with the message requesting that House will reconsider the bill or any specific provisions will consider the desirability of the amendment. He may recommend his message a bill is returned to the House for reconsider the and it is bill is passed again by the House without amendment presented to the governor. Governor shall not withhold assent. So provided further that the governor shall not assent but shall reserve the consideration of president and opinion of governor would if it is become law so derogate from the power of high court as to endanger the position of the court. So this is important things which is provided here. Reservation of bill for the president under article 201 when a bill is reserved for the governor for the consideration of president shall declare either that assent to the bill or that withhold the assent provided where the bill is not a money bill a president may direct the governor to return the bill to the house and state together with such message mentioned under 200 bill is returned to the house shall reconsider it accordingly within the 6 month date of receipt it is again passed by the house of without amendment it shall be presented to the president for his reconsideration. Financial bill under article 202 annual financial statement of the governor to laid before the house legislature and estimate receipt expenditure of the state part refer to the annual financial statement. The estimate of the expenditure embodied in the annual financial statement the sum required to meet the expenditure by the constitution charge consolidated fund of India if the sum required to meet the expenditure proposed to be made from the consolidated fund shall distinguishing revenue account or other. The following expenditure shall be charged on the consolidated fund of India. So that is emoluments of the governor and salary allowances speaker and deputy speaker of the legislative assembly, debt charged by the state liable to the interest sinking fund and redemption charges, expenditure in respect to the salary allowances of the judges, any sum judgment decree accord and any other expenditure declared constitution for the law. Article 203 procedure of the legislation with respect to estimate. So estimate is related to the expenditure charge upon consolidated fund of India and it shall be construct preventing discussion. Now so much said estimated relate to the expenditure shall be submitted demand for the grants and assent to the refuse to the assent. So article 2 no demand for grant shall be made except the recommendation of the governor. Article 204 as soon as possible grant under this has been made by the assembly there shall be introduced a bill to provide appropriation out of consolidated fund of India. Okay, the grant are made by assembly the expenditure charge of consolidated fund of state but not exceeding now next is no amendment shall be proposed to any such bill in the house either house of legislature or state which will have effect of varying amount of altering the destination of the grants varying amount. So decision of the person presiding as to whether an amendment is inadmissible under clause shall be final subject to provision of this money no money shall be withdrawn from the consolidated fund of India except the appropriation made by the provision. Okay, supplementary and additional grant 205 204 is particular service for the current financial year and if any money is spent on any serving during the financial year excess amount for the year caused the laid before the house or house legislature so showing the estimated amount of the expenditure close to presented to the legislative assembly. So this close relation with the statement of expenditure demand also any law by made authorizing the appropriate money by consolidated fund of India meet the expenditure grants in respect to the demands and effect of relation to the annual financial statements and that grant ends law to made for the authentication of appropriation money out of the consolidated fund meet the expenditure or grants. 206 is vote on account. So it is what this is vote on account. Important article. So notwithstanding anything foregoing provision of chapter it make the grant advance respect to estimated for any part any financial year completion of the procedure prescribed in 203. So voting of the grant are passing the law in accordance with the 204 to make the grant meeting unexpected demands upon the resources and magnitude of indefinite character. It is unexpected and indefinite, so that was cannot be stated detail, but annual financial statement to make the exceptional grants. Exceptional, one is unexpected, indefinite and exceptional grants. This is there shall be authorized by the law of withdrawal money from consolidated fund of India for purpose which is provided. Now the provision of the 203 and 204 shall be effect relating to making the grants and law under relation making grants with regard to any expenditure mentioned in the annual financial statement. 207 special provision for the financial bill. So Article 199 not introduced in the mood except on the recommendation on the governor. So this is the special provision for the financial bill. So special provision it is in 207. So provision should not be introduced in a council provided that recommendation shall be required moving the amendment making provision for reduction abolition of the tax. So if there is a reduction or abolition or any tax, that is in 207 special provision. Bill amendment shall not be deemed to make provision for any matters forced by reason only that provided imposition of the fines and demand for payment fees, okay, alteration, abolition, imposition, remission, regulation of any tax of local authority also. A bill which is enacted both into the operation would be expenditure from consolidated shall not be passed by the House of Legislation except unless the governor recommendation is not there. Okay, so next is what is the legislative power of the ordinance. So under Article 213, power of the governor promulgate the ordinance if any time except when the legislative assembly state in session or when there is a legislative council, except when both the house are in session, the governor is satisfied the circumstances are exist to render it necessary for him immediate action to take the immediate action to promulgate an ordinance. So a bill containing same provision would be under the constitution required the president introduce thereof in the legislation. So इसका वही इफेक्ट होगा कि जैसे हम कोई बिल पारित करते हैं, he would have a deemed to necessary to reserve a bill containing the same provision consideration of president. So अगर ऐसा कोई बिल है तो he can go for the consideration of president. An act legislation of the state containing the same provision would under the constitution have been invalid unless having been reserved for the consideration of president it had received assent of the president. Okay. An ordinance promulgated under the article shall have same force and effect of act of legislation. It is same as a act of legislature of the state. So now now shall be laid before the legislative assembly or where there is a legislative council before both the house and shall cease to operate expiration of the 6 week or before expiration of the resolution disapproving agreed the council if upon the passing the resolution as the case may be on the resolution being agreed, so may be withdrawn at any time of the governor. It can be withdrawn from the any time of the governor. Explanation where the House of Legislation of the state having legislative council are summoned to the assemble on different dates. The period of 6 weeks shall be reckoned and from later on those dates for the purpose of this clause. If and so far the ordinance under this article made provision would not be valid enacted act legislation on the state for governor, provided that the purpose of the provision of the constitution relating to the effect of act of this is act of parliament and the present shall be deemed to act the legislation on the being reserved for the consideration of the president. Appointment of the judges of the High Court under Article 217. Each judge of the High Court appointed by the President under the warrant of this hand and seal. So, Chief Justice of India and the Governor of the state, and in case of the appointment of the judges of Chief Justice of High Court, and hold the office at additional acting जो भी होते हैं, that is in 224. जज में राइटिंग अंडर एड्रेस टू द प्रेसिडेंट रिज़ाइन कर सकता है. जज में रिमूव फ्रॉम द ऑफिस प्रेजेंट इन मैनर प्रोवाइडेड आर्टिकल 124 के अकॉर्डिंग ही में रिमूव्ड बाय द कोर्ट. द ऑफिस ऑफ द जजेस शैल बी वेकेटेड हिज बीइंग अपॉइंटेड बाय द प्रेसिडेंट टू बी ए जज ऑफ सुप्रीम कोर्ट ट्रांसफर्ड बाय द प्रेसिडेंट टू बी ए हाई कोर्ट विद इन द टेरिटरी। तो ट्रांसफर कौन करता है? बाय द प्रेसिडेंट। ओके, so a person shall not qualify for appointment of judge of high court unless he is a citizen of India and at least 10 year hold a judicial office in the territory of India। so 10 year टेरिटरी ऑफ इंडिया में उसने वर्क किया हो, एटलीस्ट 10 ईयर एडवोकेट ऑफ हाई कोर्ट, एडवोकेट ऑफ हाई कोर्ट हो 2 और मोर सच कोर्ट्स में, ठीक है। सो दिस इज 3 क्वालिफिकेशन। फर्स्ट इज द सिटीजन ऑफ इंडिया होना चाहिए, सेकंड है कि 10 ईयर तक टेरिटरी में वर्क किया हो, थर्ड इज द एडवोकेट एट 10 ईयर तक उसने किया हो वर्क। सो पर्पस ऑफ द क्लोज हैं, in computation of period during this person have a judicial office in the territory, there shall be included there is a judicial office during which person has a advocate of high court or member of tribunals। In computing this included the period during this person judicial office of the member tribunals। so ये extra clause हैं इसके, ठीक है। now है oath of the judges of the high court। so article 219, this is the oath and affirmation of the judges of high court। every person appointed a judge of high court before enter upon his office make the subscribe before the governor। तो oath कहाँ होती है? गवर्नर के पास में। और some person or the some person appointed by behalf of him affirmation according to the purpose of third schedule। presidential rule article 356, the president on receipt of the report of the governor satisfied that arisen the situation। कैसी situation है कि assume himself all any function of the government of the state and all the any power of the vested governor or any body authority state other than the legislation, declare that power of the legislation of the state shall be exercised by under the authority of parliament। so now अब क्या होगा कि authority कैसे चलेगी? authority of parliament वर्क करेगा यहाँ, ठीक है। मेक सच इंसिडेंटल कॉन्सिक्वेंशियल प्रोविजंस नेसेसरी डिजायरेबल इंक्लूडिंग द प्रोविजंस ऑफ सस्पेंडिंग इन्वॉल्व पार्ट ऑफ द ऑपरेशन प्रोविजन कॉन्स्टिट्यूशन रिलेटिंग टू द authority। now provided every proclamation under the article is given before the each house of parliament and except where it is a proclamation revoking of the previous proclamation cease to operate expiration of the 2 months before the expiration of the period it is approved resolution by both the house of parliament। तो ये जो प्रेसिडेंशियल रूल लगाया गया है 2 मंथ तक इसको यहाँ से पास होना है रिवोकिंग के लिए। provided that if the proclamation revoking a previous proclamation is issued at the time and house of people is dissolved, the people take place during the period of 2 months refer to the clause and if resolution approved by this, so proclamation shall cease to operate expiration of the 30 days from the date of house of people in the first sites after the constitution unless the expiration of the 30 days resolution। now proclamation so approved shall revoked and expiration of the 6 month तक इसको चलाएंगे and provided like maximum 3 year तक जाता है ये, ठीक है। so passed by the both the house of parliament and resolution पास होगा आफ्टर देन फर्दर 6 मंथ तक आप पास कर सकते हैं। इट वुड बी अदरवाइज हैव बीन सीज टू ऑपरेट बट प्रोक्लेमेशन शैल बी सीज रिमेन द फोर्स ऑफ 3 year maximum 3 year। ओके, so provided further if the resolution of the house of people take during such a period 6 months, resolution is approving the continuous force of the proclamation have been passed by the council of the state and proclamation shall cease to operate at the expiration of the 30 days एंड मैक्सिमम 3 year है, बता चुके हैं आपको, ठीक है। प्रोक्लेमेशन ऑफ इमरजेंसी इज ऑपरेट इन द वॉल ऑफ इंडिया एज पर द वॉल ऑफ द पार्ट ऑफ द स्टेट टाइम ऑफ पासिंग द रेजोल्यूशन। द इलेक्शन कमीशन सर्टिफाई करना चाहिए कि प्रोक्लेमेशन अप्रूव ड्यूरिंग द पीरियड स्पेसिफाइड रेजोल्यूशन नेसेसरी अकाउंट ऑफ डिफ़िकल्टी होल्डिंग द इलेक्शंस, तो तभी वो उसको लगाया जाएगा अगर इलेक्शन कमीशन जो है वो सर्टिफाइड कर दे। ही सर्टिफाइज दैट देयर इज ए प्रॉब्लम इन होल्डिंग द इलेक्शंस। ओके, सो दीज आर सम थिंग्स। इम्यूनिटीज़ में क्या है? अंडर आर्टिकल 361 प्रोटेक्शन ऑफ प्रेसिडेंट एंड गवर्नर and Raj Pramukh. So President and Governor Raj Pramukh of state shall not answerable to any court for exercising the power and duties and provided the conduct of the President may be brought under review of the courts and tribunals Okay, and provided further that nothing is closed shall be construct restriction. No criminal proceeding shall be instituted against the president and governor. तो कोई criminal proceeding नहीं होगी. No process for the arrest of imprisonment of president or governor of the state shall be issued in the court. तो कोई अरेस्ट भी नहीं होगा, imprisonment भी नहीं होगा. No civil proceeding claimed a governor state shall be instituted respect to the any done done by the personal capacity. So कोई सिविल प्रोसीडिंग भी नहीं होगी. ठीक है. सो ये 2 मंथ का इसमें पीरियड है वैसे गवर्नर के लिए, अंटिल द एक्सपायरेशन ऑफ द 2 मंथ्स नेक्स्ट आफ्टर नोटिस राइटिंग हैज़ बिन डिलीवर टू द प्रेसिडेंट. ठीक है. और ये प्रेसिडेंट के केस में 40 डेज होता है, यहाँ 2 मंथ है. स्पेशल रिस्पॉन्सिबिलिटीज़ में है 239 एडमिनिस्ट्रेशन ऑफ द यूनियन टेरिटरी. तो प्रोवाइडेड द पार्लियामेंट बाय लॉ दैट यूटीज ऑफ द एडमिनिस्ट्रेड बाय द गवर्नर. ओके, अगला है एनीथिंग कंटेन द पार्ट 6 सॉरी. सो ये क्या है, पार्ट 6 जो है कॉन्स्टिट्यूशन का, अपॉइंटमेंट ऑफ द गवर्नर स्टेट एज ए एडमिनिस्ट्रेटर एडजॉइनिंग यूटी शैल एक्सरसाइज फंक्शन सच एडमिनिस्ट्रेटर इंडिपेंडेंटली. ओके, 243 में है फाइनेंस कमीशन रिव्यू करना फाइनेंशियल पोजीशंस को, तो गवर्नर ही करते हैं. एज 73rd कॉन्स्टिट्यूशन अमेंडमेंट 1992 कॉन्स्टिट्यूशन फाइनेंस कमीशन रिव्यू द फाइनेंशियल पोजीशन ऑफ पंचायत्स ऑल्सो. नाउ द प्रिंसिपल्स क्या हैं, डिस्ट्रीब्यूशन बिटवीन द स्टेट एंड पंचायत के बीच में जो नेट प्रोसीड हो गया या फिर विच मे बी डिवाइडेड बिटवीन देम एंड अलोकेशन ऑफ बिटवीन देम. ओके, द determination of the taxes, duties and the tolls and the grants in ads from the consolidated fund of India. The measure needed improve the financial position of the panchayat. Any other refer to the financial commission by the governor interest of sound finance of panchayat. Legislation of the state may law provide for the composition of the commission and qualification. ठीक है. Commission shall determine the procedure and shall have the power to perform the functions and the governor shall cause every recommendation made by the commission under with the memorandum of this. 243 why, that is finance commission. So I is what, I is a finance commission for the panchayat and Y is for the municipality. So distribution of the state and the municipality of net proceed, taxes, duties and tolls, the determination of the tax, duty, toll, fees between of them, the granted net to the municipality from the consolidated fund of India. Measure needed improve the financial position of municipality. Okay, now next one is 371D. This is the special provision respect to the Telangana. So that is also equitable opportunity facilitate the people belonging to the different parts. So this is for the Telangana. So governor has a special power for that in D. And other than this, we can see tribal area. Okay, so in the E, that was the central university in the Telangana. So this establishment of that. And 32nd amendment, that was 1973, any post of under government of any local authority in that particular area, that is also. And in 1956, any post under the government state of Hyderabad, that is related. This closes all about the Hyderabad in the Telangana. And next one is the schedule in tribal area. So in under article 244, administration of the scheduled tribes and provision of the 6th schedule. So 6th schedule is under governor shall appoint administration of the tribal areas like Assam, Meghalaya, Tripura, Mizoram. 5th schedule, that was provision of the administration control of the scheduled areas and tribes. And part A, that was interpretation and executive power of the states of scheduled area and the report to the governor to the president regarding the administration of these areas. Part B, administration and control of scheduled areas and scheduled tribes. So that is also provided under the governor to conduct the meetings to all the incidental and number of the member of council, mode of the appointments and chairman of council. Okay. Governor may make regulation for peace and good government of any area of the state of scheduled area. प्रोहिबिट कर सकता है, रेस्ट्रिक्ट कर सकता है लैंड बाय द अमंग मेंबर्स ऑफ शेड्यूल एरिया, रेगुलेट करेगा अलॉटमेंट ऑफ द लैंड, रेगुलेट वगैरह। शेड्यूल एरिया के अंतर्गत डायरेक्ट करेगा। व्हाट इज़ द शेड्यूल एरिया? इंक्रीज करना, डिक्रीज करना, अल्टर करना बाउंड्रीज को, दैट इज़ ऑल्सो। अमेंडमेंट ऑफ द शेड्यूल, सो अमेंडमेंट करना शेड्यूल एरिया में। सो पार्लियामेंट में बाय पार्लियामेंट तो लॉ प्रोवाइड करता है, ठीक है, बट no such clause is mentioned in the sub paragraph, but paragraph shall be named to amendment, या amendment की ज़रूरत होती रहती है। So this is all about the powers of the governor and how governor works in the state, and you can learn about the governor related clause.